case briefs, and so much more. LSData's got what you're looking for.
In 1958, the United States Court of Appeals for the Second Circuit heard a case, Continental Casualty Company versus Beardsley, which examined the issue of copyright in insurance forms. The dispute began in the late 1930s when insurance broker Beardsley created a blanket bond to cover lost securities. Continental Casualty Company sued Beardsley, seeking a declaratory judgment that his copyrights were invalid and damages for infringement, unfair competition, and antitrust violations. In response, Beardsley counterclaimed that Continental infringed on his valid copyrights and was also liable for unfair competition. The district court determined that while the introductory narrative of Beardsley's plan was copyrightable, the actual forms were not. The court granted declaratory relief and an injunction but rejected claims of unfair competition from both parties and Continental's antitrust claim. Both parties appealed the decision. The Second Circuit Court of Appeals upheld the lower court's ruling that Beardsley's plan was a general publication, resulting in the forfeiture of his copyright. Furthermore, the court found that insurance forms can be copyrighted, but infringement only occurs when someone copies a substantial part of them without permission. As a result, the court granted an injunction but modified it to apply only to the forms included in the forfeiture. The court dismissed Continental's claims of unfair competition and antitrust violations, and no accounting or attorney's fees were awarded.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.